there is no repeal in CI 99 of Order 22, and we would respectfully invite your lordships to be guided by the wisdom of the Nigerian Supreme Court and its various judges in its consideration of interrogatories. I would also respectfully refer your lordships to the work of Justice Marfo Sang, A Practical Guide to Civil Procedure in Ghana, in which at page 107, actually I think those were in the days before he became a lordship, but at that page 107, and his lordship adverts to the use of interrogatories and provides a piece of practical wisdom that we have been guided by in our preparations for this petition. He says that the answers to the interrogatories, which are formulated in the form of an affidavit, may be put in evidence by a party at the trial of the action. Now, my lords will notice that in the witness statement that we have filed, in one of the two witness statements, the witness actually makes reference to the fact that we have filed not only the leave for interrogatories, but we also filed a request to admit facts, all of which are within these pre-trial processes. And in the case of the interrogatories, if leave were granted and those answers were available, then as Mr. Marfo Sang, as he then was.
No, I think it was in the Court of Appeal.
As a writer.
Exactly. So the indication that has been given in that witness statement is that we would expect that the answers to those interrogatories would be available to put in evidence, which will then limit the scope of controversy, and therefore it would limit any additional recourse to oral testimony or to testimony that would be regarded as controversial, because it would be in evidence in a manner which is regarded as uncontested. My lords will also appreciate that in respect of the matter concerning the request to admit facts, which is not an issue in this review, but I'm just drawing attention to it in the context of how we believe that these pre-trial processes actually aid to achieve expeditious justice. Because essentially, both the responses to the interrogatories and the responses to the request to admit facts narrow down the issues. And it is as a consequence of that, for instance, that we are now in a position, instead of having 5 witnesses, to limit ourselves to 2 witnesses, because the request to admit facts, for instance, within the 14 days that those facts are requested after the 14 days, if they are not admitted, they are taken, if they are not answered, they are taken as admitted. So we are making a search to determine when it was served on them, and then we will be able to seek leave, if need be, for a supplement to the statement to the witness statement, which would then enable that to be in evidence. So, my Lord, we are grateful to Mr. Malfo for those words of practical guidance in his treatise on a practical guide to civil procedure in Ghana. Now, we respectfully submit that the same approach of this court in Republic and High Court Ex parte Magna International Transport, that same approach is found in this court's decision in Mona and the Attorney General. Where again, that is 2013 Supreme Court of Ghana Law Report, page 502. That court was faced with an issue arising from an amendment to Rule 55. And that amendment was by reference to Rule 71B in CI 74. And as it turned out in that case, Rule 71B actually had a heading, no review, suggesting that it was purposing to prevent reviews. And this is what the lordships concluded. And I refer to the judgment of Justice of the Supreme Court Benin at page 512. Thus, when the Rules of Court Committee was charged under Article 64(3) of the Constitution with the responsibility of enacting rules to regulate the conduct of the practice and procedure in presidential election petitions, it meant the substantive laws were different from what the committee was empowered to do. The committee was not empowered to amend the substantive law without express authorization. One such substantive law in place is the right of review given to the Supreme Court by virtue of Article 33(1) of the 1992 Constitution. Review is not a matter of mere procedure, but an important and substantial constitutional right. Any attempt to alter the right of review will be ultra vires the functions of the Rules of Court Committee. And any attempt to remove the Supreme Court's review jurisdiction or a party's right to apply for review, except through an amendment following due procedure under the 1992 Constitution, will be unconstitutional. Now, our argument is by parity of reasoning. We're not saying that exactly the same circumstances are here. We're saying that by parity of reasoning, if there were intended to be a repeal of a well-established process, such as the pre-trial process of interrogatories being filed, or other discovery processes, if there were an intent to do that in CI 99, it would have had to be very express in order to achieve that result. That result cannot be achieved by means of an implication being drawn that the timelines do not allow for that.
Mr. Chikata,
Yes.
is there a difference between a constitutional provision that is impliedly taken away because of CI and a provision that is resorted to in order to do justice? Is there a difference? I'm thinking of your parity of reasoning, and I'm wondering why you would compare apples and oranges in that way.
My lady, as I indicated, we are not suggesting that they're exactly the same circumstances. But in each case, in the case of the ex parte Magna authority, which says that there can't be an implied repeal, in the case of the Bernard Mona situation, which says that a rule of the Rules of Court Committee cannot take away a constitutional right. In each case, we are talking about an existing right, an existing practice and procedure. If it is being sought to be taken away, one, as ex parte Magna says, it has to be explicit. It can't be done by implication. And two, in the case of the constitutional situation, the position is that it cannot even happen at all. So that is in extremis. That is in extremis where it is simply impossible. But I'm saying that...
That is why I'm wondering why you would compare a situation in extremis with the situation that you are talking about and reasoning that by parity of reasoning. That's what I'm referring to.
Because in principle, in both cases, you do not have an express repeal of an earlier CI. You do not. In both cases, there isn't. In fact, that is why in the Bernard Mona case, even though the Rules of Court Committee may have thought that they were taking away the power of review and they put no review at the top, even though they put that, the court decided that it did not have that effect. Because looking at, and my Lord, again, this is a matter of looking at the language. The Bernard Mona decision is absolutely on all fours because the court looked at the terms of the amendment. The terms of the amendment showed clearly that it was not seeking to review. I'm sorry, it was not seeking to take away the power of review. The terms, and we are saying respectfully that the terms of CI 99, nowhere do the terms of CI 99 seek to take away the power to have interrogatories served in Order 22. So there is a clear parallel because the court is saying, let us look at what the so-called amendment is trying to do. Let's not even bother with the heading. The people in the Rules of Court Committee may have thought that they were taking away the right of review. But let us look at the words. And those words did not indicate that the right of review was being taken away. In the same way, we are respectfully saying to your lordships that the words in CI 99 nowhere say that they are taking away the powers under Order 22 of CI 47. Nowhere. And I would respectfully challenge anyone to point to any provision in CI 99 that seeks to take away what is provided for in Order 22 of CI 47. And my lords, we would respectfully also draw your attention to the provision in Article 1294 of the Constitution, which states that for the purposes of hearing and determining a matter within its jurisdiction, and the amendment, execution, or the enforcement of a judgment or order made on any matter, and for the purposes of any other authority expressly or by necessary implication given to the Supreme Court by this Constitution or any other law, the Supreme Court shall have all the powers, authority, and jurisdiction vested in any court established by this Constitution or any other law. So it is without a shadow of doubt that those provisions in CI 47 or the 22 in respect of pretrial procedures, those provisions are available to the Supreme Court. And it is on the basis of those provisions that the Supreme Court in 2013, in a petition brought by Nana Addo Dankwa Akufo-Addo, had recourse to Order 22 of CI 47. Our submission is that it cannot be that just because this petition is by John Dramani Mahama, it cannot be that it cannot be.
Mr. Chigata, please, let's try to.
My Lord,
it's okay.
Respectfully, my argument is that there cannot be a different interpretation of the law.
With due respect, if the 2013 case is cited, then it will be clear to all of us. That's my worry. What I'm saying is that if it is a reported matter, yes, if it is cited in course of arguments, yes, that would be the appropriate thing.
Mr. Chigata, and additionally, the 2013 election petition was not done under CI 99. So that is the change, rather than the personalities involved. I think you
Yes, my lords, I believe I have indicated that nothing, that's my first argument, nothing in CI 99 took away that authority. I've indicated that. And therefore, and building on that, I'm saying that it cannot be any different from one petitioner as against the other. We'll leave out the names of individual petitioners, but it cannot be different as between one petitioner
Mr.
or
Chigata,
the other.
can you explain to me how come the Rules of Court Committee was seized of this matter after 2013 and still did not make this provision?
And so what?
And still did not make this specific provision that you are saying somebody benefited from, and so everybody must benefit from. How come the Rules of Court Committee had another opportunity to make rules and did not say anything about it?
My lords, as I've indicated in answer to your previous question, I frankly have no knowledge of the deliberations of the Rules of Court Committee, and I'm not, with respect, willing to go on an expedition into the minds of the membership of the Rules of Court Committee as to how come they did this or they didn't do that. That, respectfully, is completely outside my terrain. What is within my terrain is what they have provided in CI 99. And in CI 99, nowhere do they say Order 22 is repealed. Nowhere.
CI 99 has repealed Order 40, Order 22, or CI 47. We just said that. You just read the ruling, the basis of your Grant A. We are strictly bound to comply with CI 99, and therefore, we will not apply Order 22 of CR 47 of 2004. We did not say CR 99 has expressly or impliedly revoked or repealed Order 22.
Yes, but
Mr. Chiquitara,
yes.
If you allow me to lie, we are just saying that we cannot apply, in the circumstance of this case, we cannot apply Order 22 on interrogatories. That is all that we said. Yes. We never alluded that CR 47 Order 22 has been amended or repealed.
Yes, but my Lord, with the greatest respect, if the circumstances are no different,
yeah.
If, my Lord, may I finish my sentence? If the circumstances are no different, except for the fact that there is now CI 99 providing a certain timeline for decision making, we are submitting that Order 22 is still capable of being operated within the timelines that are given in CR 99. Nothing stops Order 22 from being implemented and the timelines not being complied with. Nothing.
If you note, the very first reason in the ruling of the court is that the crucial issue of relevance has not been established in the petition. That was the very first reason.
And that crucial issue of relevancy is referred in the ruling paragraph, the sentence just before that. Interrogatories under common law is discretionary. It should be granted or refused. Interrogatories under common law. We did not seek interrogatories under common law. We are seeking interrogatories under Order 22 of CI 47, and we are saying with respect, that if it is a question of relevancy, I mean respectfully, if it is a question of relevancy we are talking about, how can it not be relevant that an interrogatory that seeks to ask, for instance, question 7, when did Mrs. Jean Aduko Mensah, the chairperson of First Respondent and the returning officer for the presidential election, first realized there were errors in figures she announced in her declaration of 9 December 2020. 8. How did Mrs. Jean Aduko Mensah, the chairperson of First Respondent and the returning officer for the presidential election, get to realize there were errors in figures she announced in her declaration of 9 December? 9. In respect of the purported corrections made to the figures in the declaration by first defendant, was there any prior process of conferring with agents of the presidential candidates? 10. Did Mrs. Jean Aduko Mensah, the chairperson, present Form 13 to all the agents of the presidential candidates to sign? And if so, did all the agents sign? 11. On which date did Mrs. Jean Aduko Mensah, the chairperson of the first respondent, post a copy of the Form 13 at the head office of the first respondent? 12. Did the first respondent record any discrepancies which were occasioned by computational and mathematical errors in the course of the collation of the result? How can it possibly be said that none of those questions, just to give examples, none of those questions is relevant to the determination of this suit? A suit in which...
Mr. Chikata, I hope you are not saying that those kinds of questions cannot be asked in cross-examination.
My lords, we have never said those kinds of questions cannot be asked in cross-examination. In fact, when it was suggested by counsel on the other side during the hearing of the application for leave that they can be asked by means of cross-examination, we made it quite clear that in fact being able to have those questions addressed in interrogatories saves time, because then you don't have to go into them in cross-examination. Why would I spend, questions in cross-examination dealing with something that has already been answered on oath? That is why we say that we have been practically guided by that wisdom, that if it is stated on oath, we put it in as evidence. So we don't need to cross-examine about it, because it's already been determined on oath. So why would we go into cross-examination? I fail to see how it does not expedite justice to have the matter answered in an interrogatory, rather than wait for cross-examination to do that. And the reason I respectfully say that we are guided by the practical wisdom in Mr. Mafusao's book is that if you prepare your case, part of the preparation is anticipating what you might do in the examination in chief of your own witnesses and what you might wait to do in cross-examination. But in preparing our case, we thought it important to have those questions dealt with in interrogatories so that we would not be burdened to have to ask them subsequently in cross-examination. In any case, your ladyship, if the questions are not relevant, how can they be allowed in cross-examination, if that is the position? If the questions are not relevant, if that is the position that's been taken, then they cannot be asked in cross-examination either.
Are you attempting to cross a bridge you have not reached?
Well, I believe you put that bridge there. Your ladyship put that bridge there. And therefore, I had to deal with that bridge. Your ladyship raised the issue of whether it can be raised in cross-examination. And, respectfully, part of the reason why we cannot wait for that bridge in the preparation of our case is that in putting forward our case, we absolutely need that evidence. It is material to our case. And we need that evidence so that we can put it in as part of our affidavit, as part of our witness statement. And we respectfully ask your lordships to grant the relief. Indeed, my lords, as we indicate in our grounds B and ground C, the ruling also claims that...
Counsel, please, I think some of these submissions are captured in the statement of case.
Yes,
if you can highlight on some of them so that you wind up.
I'm winding up. But I also had to respond to the questions of your lordships. My lords will see that it is stated that Rule 69C4 not only sets timelines, but it implies, and these are the words in the ruling, it implies that even amendments ought not to be sought and granted as well as joinder of parties. Now, my lord, so this is the legal basis on which that exercise of discretionary power is being exercised, that even amendments ought not to be sought and granted as well as joinder of parties. We are saying with the greatest respect that that is a fundamental error of law. Nowhere in CI 99 does it say that amendments ought not to be sought and granted simpliciter. Nowhere. No.
In any case, we granted an amendment.
I'm sorry.
We have granted an amendment in this case to the petitioner.
Because it is allowed in the rules.
So that is not what we meant.
Well, but that's what is stated in the ruling. It says it implies
the rule does not allow amendments, substantive amendments to the grounds.
My lord, I just read from the ruling. There's no qualification.
Yes, but that is not. That is just as you said. You can't go into our minds. You can't go into the minds of the rules of court committee members.
But we can go into the letter of your ruling.
Yes, so that is not what we meant. The rules does not allow substantive amendments to grounds and all that. Other than that, would you have granted you the amendment that you sought?
My Lord, at a minimum, what your Lordship just said suggests that your Lordship should, at a minimum, review your ruling so as to qualify the reference to amendments appropriately. Because we respect nobody reading the ruling that you've given can see the word substantial in that. Nobody can see that. And in any case, in CI 99 does not, my Lord, with respect, I leave my submission at the point that that statement, as it stands in the ruling, is not borne out by CI 99. I leave it at that, and it is obviously up to your Lordship to determine ultimately whether indeed Rule 69(4) says or implies that even amendments ought not to be sought. My Lord, with respect, I mean, the amendment that we sought and that was granted, I mean, was a very insubstantial and frankly a clerical error which was corrected. That should not be touted as a reason for somehow not accepting the argument that we are making. My Lord, my final submission is that this court fundamentally erred in failing to appreciate that its discretion ought to be exercised in accordance with Article 296 of the Constitution. And that Article 296 makes it clear that where in this Constitution or in any other law discretionary power is vested in any person or authority, that discretionary power shall be deemed to imply a duty to be fair and candid. B, the exercise of the discretionary power shall not be arbitrary, capricious, or biased either by resentment, prejudice, or personal dislike, and shall be in accordance with due process of law. We are respectfully submitting that in respect of your discretionary power to grant leave for interrogatories, there was, with respect, a duty to be fair and candid, and not to act in a manner that is arbitrary or capricious. And our respectful submission is quite straightforward in this regard. Our respectful submission is that in terms of even a determination about the relevancy of the interrogatories as we had drafted them and the questions, in terms of a determination of relevancy, your Lordship should at least have considered the terms of the questions posed in the interrogatories by reference to the issues in this case. Because if your lordships had made that reference to the issues in this case and to the questions that we have posed, with the greatest respect, it would be perfectly obvious that those questions were legitimate questions that required answers to be provided. So it is not sufficient just in one fell swoop for it to be said that the crucial issue of relevancy has not been established. With the greatest respect, it is not. It is not an exercise of discretionary power consistent with Article 296 for there to be such a disregard of the terms of our interrogatory.
My lords, we are opposed to this application for review, and we rely on the depositions in the affidavit in opposition and the statement of case that we filed. My lords, under CI 16, Rule 54, the court may review any decision made or given by it on any of the following grounds: exceptional circumstances which have resulted in miscarriage of justice, or discovery of new and important matter or evidence which, after the exercise of due diligence, was not within the applicant's knowledge or could not have been produced by him at the time when the decision was given. My lords, the submissions that we have heard today have not canvassed any new matter or exceptional circumstances for which this court's review jurisdiction should be exercised. My lords, what we have rather heard was a rehashing of the arguments that was before the court when the decision was taken on the 19th of January. In this regard, my lords, may I humbly read the decision of Adade GSE in the case of Mechanical Lloyd Assembly Plant versus Nati, reported in 1987-88, 2 Ghana Law Report 598, Supreme Court. My lords, with your kind permission, it says, let me say at once that for all I know, virtually every judgment on this earth arrived at as a result of evidence gathered from several sources can be criticized. A Privy Council judgment put in the hands of any lawyer along with the evidence grounding it can be criticized in the same way as a High Court judgment can be. A person who has lost a case will almost instinctively feel that the judgment must be wrong. And why not? If he had won, the decision will be right. So if he lost, how could the court be right? But the mere fact that a judgment can be criticized is no ground for asking that it should be reviewed. A review jurisdiction is a special jurisdiction to be exercised in the exceptional circumstances. It is not an appellate jurisdiction. It is a kind of jurisdiction held in reserve to be prayed in aid in the exceptional situation where a fundamental and basic error may have inadvertently been committed by the court, which error must have occasioned a gross miscarriage of justice. The review jurisdiction is not intended as a try-on by a party after losing an appeal, nor as an automatic step from an appeal. neither is it meant to be resorted to as an emotional reaction to an unfavorable judgment. My lords, it's my submission that the arguments we have heard today by the applicant is just an emotional reaction to an unfavorable judgment quoting Adade, and therefore this application should be dismissed. That's my submission.
My lords, we are opposed to this application, and we rely on the depositions in our affidavits in opposition filed on the 25th of January 2021 and our statement of case filed on the same day. My lords, we wish to make the point from the very beginning that the court grounded its dismissal of the application for interrogatories on 3 key points, and not as counsel for the petitioner has sought to suggest on 1 point. The court raised the issue of relevancy, the issue of lack of matters in controversy, and then made the point, the third point, that CI 99 establishes strict timelines, and therefore the application will not, therefore Order 22 will not apply in this circumstance. So the first myth that has to be blown away is that the court never ever said or implied that CI 47 had been repealed or will never apply in a petition, in an election petition. This is a gross misconstruction.
He said Order 22. Order 22.
Yes, Order 22 or CI 40. I'm saying that my submission is that this interpretation is a gross misconstruction and an impermissible gloss that counsel seeks to put on what the court said. Now, my lords, my second point here is counsel has raised the issue of relevancy. Now, the issue of relevancy goes to the issues to be determined in the trial. And if your lordships look at the issues to be determined in trial as set out, it becomes very apparent that these matters that were raised in the interrogatories are not really germane to the issues to be determined in trial. The issues are: 1, whether or not the petition discloses any reasonable course of action; 2, whether or not, based on the data contained in the declaration of the first respondent and the second respondent as president-elect, no candidate obtained more than 50% of the valid votes, as required by Article 63(3) of the Constitution. 3, whether or not the second respondent still met Article 63(3) of the 1992 Constitution threshold by the exclusion or inclusion of Techiman South constituency presidential election results. 4, whether or not the declaration by first respondent dated 9 December 2020 of the results of the presidential elections conducted on 7 December 2020 was in violation of Article 63(3) of the Constitution. And finally, whether or not the alleged vote padding and other errors complained of by the petitioner affected the outcome of the presidential election. My lords, this is my submission, that it is more than obvious that the issues sought in the interrogatories, are not really relevant in the determination of these matters. Secondly, the court's second reason was that the issues sought in the interrogatories were not related to issues in controversy. That is, the issues joined by the pleadings. It is then only after these two fundamental reasons that the court makes the observation that in any case, or in addition, CI 99 prescribes strict timelines. Therefore, the court will not apply Order 23. In this circumstance, what is meant by this circumstance? That is, all the issues that have been looked at or discussed in the ruling. We all know that when you are doing interpretation, you do not just pick one sentence or paragraph out of a whole construction and make a meal out of it, as counsel for applicant seeks to do. My lords, let me then make the point that the reference to the Monarch case, my lord, is misconceived and involves a deliberate attempt to put an impermissible spin on the Monarch case for purposes of this application. In the Monarch case, what the court held was that rule in CI 74 that sought to take away the right of review was unconstitutional. Now, in order that the petitioner can suggest the relevance of the Monarch case to the present application, he seeks to suggest that the CR 99 has impliedly repealed the right to interrogatories. That is the whole point. Now, if the court, as I've demonstrated, has nowhere said that CI 99 has repealed or amended the right to apply for interrogatories under Order 22, the whole argument of the relevance of the Monarch decision falls flat. It crumbles, my lord. Now, similarly, my lords, we believe that it is important to recognize the point that every application that is brought for interrogatories must be decided on its own terms based on the general principles governing the grant of application for interrogatories. Therefore, it is again misconceived for counsel to suggest that because in 2013 an application for interrogatories were granted, automatically the Supreme Court is bound any time an application for interrogatories is brought in an election petition to grant it. My lord, that is poor logic.
We are used to our jargons. Maybe you can say that it's misconceived.
Very well, my lord.
Yeah, we are used to our jargons. We are
my lord,
other professions.
My lord, yeah. My lord is well taken. Yeah. I withdraw that point. But my lord, I believe that it is completely misconceived to suggest that because in 2013 we were granted interrogatories, in this case we should be granted interrogatories. Again, the lords, my lords, I want to refer to the Nigerian decisions. My lords, and all the other decisions that were referred to in paragraphs 23, 25, and 26 or so of the statement of case. And also, in all those decisions, the court, exercising its discretion, held that in the particular situation, the applicant was entitled to the grant of interrogatories, and therefore held that the refusal was wrong. So, my God, Lords, one cannot just cite those examples to determine that the refusal in this particular case was wrong. Again, the applicant has the burden of demonstrating to the court how the refusal in this particular case was wrong. And furthermore, he has an obligation to demonstrate, one, that the error was a fundamental error, two, that fundamental error occasioned them a gross miscarriage of justice. And thus it's our submission that the applicant has failed to demonstrate these very basic conditions to grant a review. In the circumstances, my lords, we pray that the application be dismissed as completely unmeritorious. Pray accordingly.
My lords, yes, respectfully.
Because I think as regards the first respondents, the opposition to the legal cited the
mechanical, yes.
case.
Exactly. And my lord, I was going to cite a more recent decision which made reference to the mechanical Lloyd case. Because, my lord, I think it's important to...
Yeah, what is the case?
This is Hannah Asi number 2. Hannah Asi number 2 and Gihok Refrigeration. 2007 to 2008.
Yeah.
Supreme Court of Ghana Law reports at page 16, which actually, it considers all the line of cases.
I think it was referred to.
My lord, it was not in our statement of case.
Yeah, it is.
My lord, I think you're referring to the draft of our supplement to the statement of case, which your lordships have thrown out of the window.
I wouldn't like Mr. Putampao to use certain words in the court of law, so please, without...
My lord, with respect, I didn't say that disrespectfully. I use that word out of the window in a light-hearted manner, but if it's offensive, I take it back. I use that word just in a sort of light-hearted manner of, so I take that back as not reflecting perhaps the circumstances here. So I was simply drawing attention to the fact that Hannah Asi is not in our statement of case. That's all. Yeah. And I would also respectfully, in relation to the point that counsel for the second respondent made about the exercise of discretionary power, I would also respectfully refer your lordship to another authority of the Supreme Court, in the case TDC and Musa against Atta Balfour. TDC and Musa against Atta Balfour. That is 2005 to 2006, Supreme Court of Ghana Law Reports, page 121. And in particular, His Lordship, Dr. Barnes' words at pages 152 to 3. Now, my lords, you also heard counsel for the second respondent suggest that the issues that you have set down are the basis on which relevancy must be determined. With all respect, those issues that you set down were actually set down after the hearing of the application for leave. After. So, unless my learned friend was anticipating that those were the issues that would be set down, respectfully, those at the time of our application for leave, those issues had not been set down, and therefore it's illegitimate for him to claim that it is in terms of that application for leave that he's arguing. And finally, my lords, the reference that is consistently being made to strict timelines under CI 99, respectfully, my lords, we are saying that what the application sought to do was actually to facilitate those timelines, especially in terms of a judgment by March being complied with, because we're not waiting for things to be done in cross-examination and so on. And my lord, if you wanted to be literal and mechanical about the meaning of those timelines, we would draw your lordship's attention to one very simple example. The timelines put filing and serving of process of the petition in January, for instance. January is stated in CI 99, Rule 69C4. It says January, filing and service. Are your lordships going to say that because we filed on the 30th of December and the process was served by the 31st of December, therefore we do not comply with the strict timelines in CI 99? Are your lordships going to say that? I mean, my lord, with respect, this very simple way of trying to interpret Rule 69C4 would lead to gross absurdity if we were to follow it.
All right.
Order, please, order.
My